Welcome once again to Lehto's Law. Here's Steve Lehto.
Got an interesting story out of Georgia, and this one's fascinating. And I don't often do stories before the courts rule, but I think we have a good guess on how this one's going to turn out. And it's so interesting, I think, that we don't need to wait for the outcome. When the outcome hits us, we'll do an update. But right now, Georgia court doubtful that property owners can boot unauthorized cars. So this is one of those things that some areas of the country will have no idea what this is all about. Other areas will go, oh yeah, of course, this is what happens. And so if you go to a private parking lot, a lot of times like near a mall, for instance, if there's some place that people like to park for one place but go to another or vice versa, or leave their vehicles there for a little while too long, they'll put up signs saying, unauthorized cars will be towed away at the owner's expense. However, there are places in Georgia and elsewhere where they'll boot your car. This is not the police. This is a private business booting your car because they say you parked too long on their property or on their property without their permission. Kamal sent it to me. Bill Rankin wrote it for the Atlanta Journal-Constitution. Georgia court doubtful that property owners can boot unauthorized cars. For years, property owners have been having cars booted if the vehicles are left parked in their lots without authorization. Now, they recently argued this case in front of the Georgia Supreme Court, and the arguments didn't go well for the property owners. At one point, the Chief Justice called the argument of the property owner crazy, and on another occasion said it was nutso, N-U-T-S-O, nutso, and crazy. The state high court is considering a class action lawsuit filed by Forrest Allen, whose tractor trailer was booted after he parked it at the Wesley Chapel Crossing Shopper Center in Decatur in February of 2018. He had to pay $650 to have the boot removed. And of course, that's what this is all about. So they boot your vehicle, and you come out, your car has been booted, you can't move it. So you notice there's a sign. The sign says, vehicles be booted. If your vehicle gets booted, call this number. You call the number, they say, yeah, if you want us to take the boot off, it's $650. So the interesting thing is, there's a distinction. When they boot your vehicle, it stays there. If they have a sign that says unauthorized vehicles be towed, they actually tow your vehicle off the property. That is actually the big distinction here. So far, a Clayton County judge and the State Court of Appeals have ruled in favor of the truck driver and have allowed his case to go forward. Now, Wesley Chapel Crossing, which is the place that was booting the vehicles and booted his vehicle, is appealing that latest decision, which got them in front of the Georgia Supreme Court. The shopping center was supported in court filings by several local vehicle immobilization companies that note there are similar lawsuits pending in the lower courts and contend an adverse ruling could destroy their business. Okay? Interestingly, the outcome of the case might turn on centuries-old common law that said that landowners could seize trespassing livestock on their property to basically pay them for damage caused by those animals. So let's suppose that you own a farm. Next to you is another guy who owns a farm. His cattle come onto your property and cause damage. And you come out there, there's his cattle, there's the damage they caused. Under the old common law in Georgia, you could grab some of those cattle to pay for the damage done by those cattle. So the people at the shopping center are now saying, this is the same thing. When you bring a vehicle onto our property and it causes us harm because it's there too long, we can boot it to get paid for the harm that was caused. But here's the deal. One of the defendants in the case started off arguing, saying property owners have a self-help right to boot unauthorized vehicles for the purpose of exercising control of their parking lots and to exclude trespassers. Exclude trespassers. Remember that word, exclude. Justice Sarah Hawkins Warren asked, why is that excluding? Isn't that detaining? Because if you want to keep them off your property, booting a vehicle does the exact opposite. It keeps them on your property. And yes, it's basically them detaining your vehicle, not excluding it. And then, of course, the defendants argued it's detaining the vehicle there at the moment, but it also deters future trespassers and protects the property. The Chief Justice was not buying it. He said, that may be your theory, but that was not the common law right. It was always categorized as a remedy for a certain type of trespass. The common law right was not to deter. It was a way for a landowner to be compensated for damage. Now, the defendants argued there should be certain remedies to cure a trespass. The judge disagreed and said, quote, "It is a crazy thing to say the normal cure for an unauthorized entry in your property is to insist that the trespasser remain on your property." He then said that's nutso under any conception of the law. Where in the world can you say a cure for trespass is to continue the trespass? So if someone's on your property, the first thing you see is, "Get off my property." You don't say, "Hey, stay there." The defendants responded, "I disagree that it's either crazy or nutso to do so. I believe businesses do so because it is effective in curing or avoiding trespassers." Chief Justice told the attorney for the defendant that property owners have two legal remedies they can use. They can tow it away and impound it. And if they don't get their car back until they pay their fees, that solves it. Or you can sue them for trespass. You know who they are. You know the damages. And many people don't know this. Trespass is another one of those things that has the dual points in the law. There's a civil action for trespass and a criminal action for trespass. So if someone is trespassing on your property and they harm something, in many states, you can sue them for the harm they do. Some states have got a statute on trespass that says even if they cause no harm, but they've trespassed, you can sue them anyways and get a statutory amount. So in some states, for instance, you might be able to sue and get $750. Even if they did nothing, they walked across your property and you can prove it. There's no trespassing signs posted. They ignored the signs. They trespassed. Some states are going to say the signs must be posted. Some states will say you have to put up certain indicators. Some say if it's fenced, it's obviously posted and so on. Depends on the state. I'm not going to get into that because there'd be 50 different videos I'd have to make. But you can sue them for it. That's a civil action. Likewise, there is a criminal action for trespass. That is, if the police are there and you say, "I would like this person prosecuted for trespass," they can be arrested and prosecuted for trespassing. That is a criminal action. So there's two actions, the civil and the criminal. And they're pointing out here that there's several things that you can do, but they are by law allowed to tow away the vehicle and impound it or sue them for trespass. So the defense attorney argued that drivers had, in essence, consented to having their vehicles booted if they were there without authorization because of warning signs posted in parking lots. And of course, one of the judges disagreed with that too. The consent part of your argument is the most troublesome to me. I think it conflates notice with consent. Meanwhile, the lawyer who represented the plaintiff in this case encountered few, if any, pointed questions from the justices. So I've watched oral arguments before at Supreme Courts and at Courts of Appeal. I've myself made arguments in front of the Court of Appeal. And I can tell you that when you make an argument for the Court of Appeals, you can sometimes guess which way they're leaning. Sometimes. But most judges try very, very hard to do the old poker face, where they'll ask a question here, they'll ask a question here. And generally speaking, you don't ever walk out confident that we're going to win. I can tell we're going to win by their reaction. You can think you're going to win based on your argument. But most of the time, the judges do not lay it out there for you. But when the judge calls your argument nutso, N-U-T-S-O, nutso, and crazy, there is a good argument that that judge at least is inclined against you. That's just, call me crazy, but call me nutso. That's just my take on this. And I think that was also the take of Bill Rankin, who wrote the article for the Atlanta Journal-Constitution. It's a great article. And I am reasonably certain that the court's going to come down on the side of the truck owner and say that private property owners can exclude people from their property. And if a vehicle gets parked in the property, they can have it towed or they can sue the person, but they cannot boot their vehicle and, in essence, seize their vehicle to force them to pay a fee that you just made up and yanked out of thin air. So that's what I think is going to happen. I'm going out on a limb here. Like I said, I don't normally do these stories until the courts actually rule. But I think we can do it here because the court said the argument was crazy and nutso. Kamal Senate, thanks a lot. Questions or comments, put them below. I'll talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Contentment comes not so much from great wealth as from few wants.